opened fire into Sandy Hook Elementary School back in 2012, killing 20 first graders and 6 educators. Another unbelievable tragedy. And I will add to that this is just one of several upcoming trials for InfoWars hosts, involving other parents who claim that Jones' public accusations were defamatory towards them. In fact, a jury selection in Connecticut lawsuit began today. The opening statements are not expected until September 6th. Stay with Law and Crime to be updated on that and the latest in that trial. But in the current case, the 7 women and 9 men, including alternates, will decide the damages in this particular case. So, Philip, let me turn to you on this first. I mean, Alex Jones, they're arguing the First Amendment issues. The trial's a little kind of crazy, but let me just correct one thing here, and I want you to explain to our audience so it's crystal. They are arguing that he hasn't had a right to defend himself. There's arguments that the judge is telling them that you just have to award money. This isn't America. How can you not have the right to be able to defend against the allegations? Well, there's a reason for that. And it happens every day in every court, in every state, in every jurisdiction, and they are very fully well aware of the consequences of a thing we call default. Philip, explain.
Just that. A summons and a complaint served upon you is not a save the date. It's not an announcement. It's not an invitation. It is legal process after which you must file a legal response, typically within 30 days. If you fail to do so, the law will deem you to have conceded and admitted all the allegations filed against you. Once a default judgment is entered, it means liability is no longer in issue. The only matter remaining is damages. Now, had he gone to court to try to set aside the judgment on the grounds he was never served, that's different. But now he cannot go back into court to try to relitigate liability or fault. The only question here now is how much? That's it. And if he files for bankruptcy, it doesn't matter, because in that default, a finding of malice was included, and malice findings resulting in judgments are non-dischargeable in bankruptcy.
Judge, I got a short period of time, about 45 seconds. You were a judge. You used to listen to these arguments. It just riles me when I see people getting up there. In fact, I don't know how a judge is allowing this to happen during the course of a trial, saying something that he's being denied when he was fully well aware and advised repeatedly that if you do not answer and you do not follow the rules, you will be in default, gets into default, now goes outside the courtroom and says he's being denied due process. Judge, is this unusual to you, or is this just common practice?
There's the First Amendment. People have a right to be critical outside of the court of what they believe was wrong with the court process.
Right.
But, on the record, I would let people say what they needed to on the record, as long as they didn't get disrespectful and run the risk of getting locked up for contempt. But it's not surprising.
Well, Judge, listen, I appreciate your commentary. Philip, always appreciate you guys being here. Good to see you again. Judge, I know you guys have got to go. Well, I'm looking forward to see you shortly. We're going to have some more guests on the other end of the break, so don't go anywhere. We'll be right back.